panel discussion now begins. Moderator, presenter, and discussants, please be seated.
The rules of this panel discussion is as follows. Presenter have 30 minutes to give their speech. The presenters will be given a 28-minute reminder with a short bell ring. When the 30 minutes time limit is up, the bell will ring twice. The presenters should then end their speech. The discussant will be given a 13-minute reminder with a short bell ring. When the 15 minutes time limit is up, the bell will ring twice. The discussant should then end their discussion. Afterward, we will have a 20-minute Q&A. Each question in the Q&A session is limited to 2 minutes. All persons who would like to join Q&A shall identify themselves by stating their name, the affiliate institution, and their title before presenting their comments or questions. There will be a 1.5-minute reminder with a short bell ring, and the bell will ring twice when the time is up. The attendant should then end their question. If you wish to join the Q&A, you may use the microphone in front of you. Please press the button on the microphone while you speak, and remember to turn it off when it's finished. If you have other questions or opinions, you can also use the speech notes placed inside the folder and pass it to the staff near you.
The topic of the second panel discussion is Entrenched Clauses of Constitution. Let us welcome the Honorable Justice Tang De-zong to be the moderator of this session with great applause.
Ladies and gentlemen, welcome to Day 2, Session 2 of the International Conference celebrating the 70th anniversary of the Constitutional Review on Taiwan. Here we are very pleased to have Professor Richard Albert as a speaker, who is the William Stamps Farnish Professor of Law at the University of Texas at Austin. It is one of the most promising comparative constitutional lawyers. Today, Professor Albert will address the judicial role in constitutional amendment and dismemberment by analyzing relevant court decisions, including interpretation number 499 of this court, in a comparative and a doctrinal way. In addition, originally we're supposed to have 2 outstanding discussants, but because one's absence, now we only have 1 outstanding discussant. That is Dr. Su Yan-tu, okay, just on my right-hand side, who is the Associate Research Professor at the Institutum Jurisprudentiae of the Academic Sinica, which I founded in the year of 2004. The presenter will have 40 minutes to speak, while each discussant will have 15 minutes to comment. Then the floor will be open to the audience. Before turning the floor over to the speaker, I would like just to say a few words. First of all, I'm very glad to see that the Judicial Yuan celebrating the 70th anniversary of the Constitutional Review on Taiwan by hosting such an international conference to facilitate mutual understanding among constitutional jurisdictions. In light of the persistent isolation of Taiwan from the global village and the concomitant desire for communication and participation, I have been enthusiastic, or to put it more accurately, strenuous in pursuing various international forums to introduce the Taiwanese experience of a constitutional review to the world, since I took the post as Grand Justice in 2011. Luckily enough, with the support of various academic institutions, I have so far achieved the preliminary success, including being invited to conduct a 1-month seminar on constitutionalism and the constitutional review on Taiwan at New York University in the fall semester of 2015, and to give lectures on the constitutional review on Taiwan, review and the prospects at Harvard Law School, Yale Law School, UPenn Law School, European Public Law Organization, Athens, Greece, Freiburg University, Trier University, as well as the Swiss Institute of Comparative Law, respectively. I sincerely hope these breakthroughs and this international conference are the beginning of more frequent or even regular exchanges between this court and the rest of the world. Secondly, while we are celebrating here the the constitutional review at its 70th year. We should not take the achievements earned for granted. This may sound harsh, yet it is true. Indeed, I felt a sense of sadness and sorrow when I read Professor Albert's article praising interpretation number 499 of this court, because we may not be able to take such a petition for constitutional interpretation from the legislators anymore. Under the newly shaped procedural requirement for petition constitutional interpretation by the legislators announced by this court on May 4th of this year, I therefore would like to take this opportunity to earnestly remind one more time my colleagues of the adverse impact of the emerging neoconservatism, if I may call it, in the court. All right, now Professor Albert, you may take the floor.
Thank you, Justice Tang, Professor Shi, Vice President Tsai, members of the Constitutional Court, members of the Judicial Yuan, Chief Justice McLaughlin, and Mr. Frank Cardle. Friends, guests, thank you so very much for having me. It's a pleasure and really an honor to be here with you today as you mark this very special anniversary. And I bring you greetings from my home country of Canada, from the United States, where I live and I work. If you spent any amount of time in the United States, you will have no doubt encountered the phrase Texas hospitality. Texas hospitality. It's a reference to how openly Texans welcome people to their state, how well they feed visitors and newcomers, how far they go to accommodate friends and visitors. And I have to say that here on my first visit to Taiwan, my very first visit to Taiwan, I hope it will not be my last, that you have fed me well, you have greeted me well with open arms, and I think I will start to use the phrase Taiwan hospitality when I go back home to Texas. Before I begin, I do want to just say a short acknowledgement to Justice Huang. Justice Huang and I have been engaged in a collaboration called the Global Review of Constitutional Law. It is the very thing that Justice Tang mentioned a moment ago as being important and necessary as this court engages in collaborations with scholars and jurists around the world. And so I want to thank Justice Huang for his participation in our annual Global Review of Constitutional Law. My subject today is constitutional change. And I want to focus on the distinction between amendment and dismemberment, a distinction that lies at the core of how we change constitutions. This distinction entails implications both for how to change a constitution and also for whether a given change is legally valid and democratically legitimate. And today my plan is to put into a larger global perspective the Taiwan Constitutional Court's interpretation of the power to amend the Constitution, a Constitution that just marked its 70th anniversary. And so the title of my remarks, I think, is fitting for a conference on the Constitutional Court. It is the judicial role in constitutional amendment and dismemberment. And I want to begin where we are standing today in Taiwan, with a case decided by the Constitutional Court. This Constitution codifies no formal limitations on what may be amended. Yet the absence of a formally unamendable rule in the Constitution has not deterred the Constitutional Court from striking down a series of constitutional amendments. In one case, the issue concerned a set of amendments adopted by the National Assembly in 1999. The court subsequently invalidated this amendment on both procedural and substantive grounds, and the case was Constitutional Interpretation 499, decided in the year 2000. The challenge began when members of the Legislative Yuan filed a petition arguing that the amendment passed by the National Assembly, where votes had been cast in anonymous ballots on both the second and third readings, that this amendment violated the Constitution's codified amendment rules. The challengers argued also that there were irregularities in the vote because some of the amendment proposals had been defeated in the second reading, but were still voted on in the third. The challengers raised other concerns, including that the amendment improperly extended term limits, that it sowed confusion about the duration of those limits, and that it improperly disqualified some persons from selection to the National Assembly. And the court ruled that this amendment was unconstitutional. The court invoked a number of principles to justify its ruling. 1, openness and transparency. 2, the norms of constitutional democracy. 3, the fundamental nature of the Constitution itself. And here is how the Constitutional Court explained how it reached the conclusion that these amendments were unconstitutional. Although the amendment to the Constitution has equal status with the constitutional provisions, any amendment that alters the existing constitutional provisions concerning the fundamental nature of governing norms and order, and hence the foundation of the Constitution's very existence, destroys the integrity and fabric of the Constitution itself. The democratic constitutional process derived from these principles forms the foundation for the existence of the current Constitution, and all governmental bodies installed hereunder must abide by this process. Powerful words by the Constitutional Court. As in other cases around the world where courts have invalidated a constitutional amendment, here in this case, the Taiwanese Constitutional Court set the Constitution itself as the standard for lawful constitutional change. The court explained that it cannot allow constitutional changes that are inconsistent with the Constitution because those changes would destroy the Constitution as it is presently understood. Now, although the court did not describe it in these terms, the court invalidated the constitutional change because the change was a constitutional dismemberment and not a constitutional amendment. The court saw its role as protecting the Constitution from changes whose effect amounts to a dismemberment of a Constitution and not a mere amendment of it. This distinction between amendment and dismemberment is central to the study of constitutional change. And what lurks beneath this distinction is a problem, and that is the problem of classification. What is an amendment and what is a dismemberment? How can we identify a change as an amendment or as a dismemberment in cases where the codified Constitution does not in its text distinguish one from the other? How do we know what is an amendment and what is a dismemberment? And the answer I want to suggest resides in how we understand constitution making. An amendment is a change to the higher law that coheres with the existing Constitution and its presuppositions. An amendment is a change whose outcome fits comfortably within the established framework of the Constitution. And so we can understand an amendment as an effort to continue the constitution-making project in the path that began at the founding moment or in an intervening refounding. Amendments can come in two types. They can be corrective or elaborative. Properly defined, an amendment is a correction made to better achieve the purpose of the Constitution. The 12th Amendment to the US Constitution is an example of an amendment properly defined. What is the 12th Amendment? Well, at the founding, those who voted for president and vice president would cast two ballots, both for the presidency. And the candidate who won the most votes became president, and the candidate who won the second most votes became vice president. As you can imagine, this concealed is a design flaw, because what happened in the year 1800 was a tie. The top two vote getters were tied. And after 36 ballots of contentious debate and wrangling in the House of Representatives, eventually Thomas Jefferson was selected as president. But this posed a problem, and so an amendment was made to the Constitution, the 12th Amendment, which required electors to differentiate their ballots, one for president and one for vice president, in order to reduce the possibility of a tie. That is a correction to the Constitution. It fixed a design flaw, a technical flaw in the Constitution. That is a proper amendment. An amendment can also be elaborative. An elaboration is a larger change than a correction insofar as it does more than simply repair the fault in the Constitution. But like a correction, an elaboration continues the Constitution-making project in line with the current design of the Constitution. Though instead of repairing an error, an elaboration advances the meaning of the Constitution as it is presently understood. For example, the 19th Amendment is properly understood as an amendment, an elaborative amendment, because it advances the meaning of the 14th and 15th Amendments, making good on the promise of equality. The 19th Amendment prohibits gender discrimination in voting. It's an expansion of the franchise, but it was not corrective in the sense of fixing a design flaw in the Constitution. Rather, it was an elaboration of the plain reading of the Constitution's promise of equality rights, all within the existing framework of the Constitution. Now, in contrast, a constitutional dismemberment is a change also to higher law that departs from our understanding of what the Constitution means, and indeed of what it allows by its spirit and its design. It seeks to transform the Constitution into something it is not, resulting in an extraordinary change that is inconsistent with the Constitution's framework or its presuppositions. It seeks to deliberately disassemble one or more of a Constitution's elemental parts, be it a fundamental right, be it a load-bearing institutional structure or design, or be it the identity of the Constitution. It is a change understood by political actors and the people to be inconsistent with the Constitution at the time the change is proposed to be made. If you want to reuse a rough shorthand, a dismemberment has the same purpose and effect, both the same, and that is to unmake the Constitution without breaking legal continuity. Now, I do want to say that dismemberment is a descriptive concept, not a normative concept. A dismemberment can achieve democratic ends, and it can achieve undemocratic ends. Let me give you an example of a dismemberment. The Civil War amendments, as they're called, are not, in fact, best understood as amendments. They're better understood as dismemberments. The 13th, 14th, and 15th Amendments consolidated the Union victory over the Confederate States, and collectively they wrote into the Constitution a ringing declaration of equality in the U.S. Constitution. But their most important function, the most important function of the Reconstruction amendments to the U.S. Constitution was to demolish the infrastructure of slavery in the original Constitution. These three amendments tore down the major pillars of America's original sin of slavery. The 3/5 Clause, the Fugitive Slave Clause, the Migration or Importation Clause, and the Proportionate Tax Clause. That is an example of a dismemberment. Another example, happy to talk about it in our Q&A, is Brexit. Brexit is a major constitutional change to the Constitution of the United Kingdom, but it is not an amendment. It is best understood as a dismemberment. Now, many courts around the world will strike down constitutional dismemberments. The reason why is not because political actors cannot choose, if they wish, to unmake the Constitution. It is because political actors, according to courts, cannot seek to unmake the Constitution using the procedures of constitutional amendment. You cannot dismember the Constitution using the procedures of constitutional amendment. Political actors must instead write an altogether new Constitution if they want to dismember the Constitution. a new constitution that is validated and legitimated by the very process of a new constitution-making effort. And so when courts have relied on the doctrine of an unconstitutional constitutional amendment, they have often drawn a line that separates a change that amends the Constitution from one that destroys it. Dismemberment is the destruction that courts are preventing when they seek to invalidate a constitutional amendment. Now, like the Taiwan Constitutional Court, courts around the world in jurisdictions as varied as Belize and the Czech Republic and India and many other places have either exercised the power or asserted the power to invalidate a dismemberment that is made using the procedures of amendment. In Belize, the Supreme Court invalidated the 8th Amendment, which was a change that would have given the legislature plenary power to alter the Constitution with no judicial review. The court ruled that this change was unlawful, null, and void because it failed to respect the separation of powers, the balance and harmony among the branches of government. And also, the court expressed its concern that the 8th Amendment, were it allowed to pass, could remove or destroy any of the basic features of the Constitution if the legislature were able to amend the Constitution without any judicial review. This theme of destruction is very important. In the Czech Republic, the Constitutional Court was faced with an amendment that sought to shorten the terms of the Chamber of Deputies. The court invalidated the amendment, and with it, the decision of the president to call new elections for that chamber. And the basis of the court's decision was what it defined as its duty to protect the material core of the Constitution as reflected in the Constitution's unamendable rule, protecting democracy. For this court in the Czech Republic, the amendment was an amendment only in form but not in substance. And the court described this amendment as an assault to democracy. And the court said that to violate the democracy principle would be the equivalent of destroying the Constitution. And so the court stepped in and said, no, we cannot allow this constitutional change to pass because it would destroy the Constitution. It would dismember the Constitution. It is not a simple amendment to it. These courts in Belize and in the Czech Republic, they weren't innovating a new theory of constitutional change when they imposed limitations on the power of amendment. They were borrowing from the Indian Supreme Court's theory of the basic structure doctrine. They were following a path that the Indian Supreme Court traced in a series of judgments from 1967 to 1981, beginning with an important case, Golaknath, in which the court laid the foundation for invalidating an amendment. When the court held that the power to amend the Constitution cannot be used to abolish or violate fundamental rights. Later, in Kesavananda, the Indian Supreme Court held that the amendment power could be used only as long as it did not do violence to the Constitution's basic structure. And a few years later, in Minerva Mills, the court invoked this basic structure doctrine to invalidate amendments that sought to diminish the power of the court by denying the court the power to exercise judicial review of legislation and of the amendment power. And so when the Taiwanese Constitutional Court invalidated the amendment in the year 2000, it was doing something that has become increasingly common for courts around the world. This doctrine of unconstitutional constitutional amendment has traveled really to virtually every region of the globe. Many high courts around the world have given themselves the task of guarding the Constitution from changes they believe would destroy the Constitution, changes that would dismember the Constitution rather than simply amend the Constitution. There is a rich jurisprudence of case law from courts around the world, including this court, that allow me to suggest to you 8 strategies, 8 justifications that high courts can use if they want to invalidate a constitutional amendment. 8 strategies or 8 justifications that a court can use to defend the Constitution from efforts to dismember it. These are 8 strategies that deal with process and with substance. And what I'd like to do in the time that remains is to walk through with you these 8 strategies, and perhaps they'll be useful to the court in the years ahead. So first, an amendment can be overruled because it was made using the wrong procedure. Many constitutions around the world now, for instance, the South African Constitution, the Canadian Constitution, they codify multiple procedures for constitutional amendment, designating one particular amendment procedure for certain parts or provisions in the Constitution. Courts could invalidate an amendment for having been passed using the wrong procedure. We can call this the subject-rule mismatch. So, in the United States, for example, Article 5 requires that a state must consent to a diminution in its representation in the Senate. So, for example, if an amendment is passed to take away a senator from Rhode Island, and if Rhode Island does not consent, as Article 5 requires, a court could declare that amendment unconstitutional as a result of the subject-rule mismatch. You need Rhode Island's consent, you did not get it, amendment is unconstitutional because you did not follow the right procedure. Second, some constitutions impose a time limit for passing a constitutional change. For instance, the constitutions of Australia, of Italy, many others, require that an amendment must be debated for a certain period of time before a ratifying vote. And part of the reason for imposing a time limit is that amending actors should debate the proposal under the same social and political conditions, within the same period of time, because only in this way can we be certain that a successful amendment has the support of a contemporaneous majority of the people and their representatives. And so a court could invalidate an amendment that violates constitutionally prescribed temporal rules for its adoption and ratification. This second justification we can call temporal limitation. Third, the third procedural basis for invalidating an amendment is a simple irregularity in administering the process of amendment. Perhaps the vote was somehow rigged or unfair, perhaps the voting machines were broken or hacked, perhaps there was voter suppression, or some other challenge that amounts to a non-trivial obstacle to casting one's ballot. And so the court could peer behind the official results of an amendment vote to interrogate the vote itself. And where the court finds evidence of irregularity, it could invalidate that amendment on that basis and call for a new vote. Fourth, an amendment might violate an important founding principle that is deemed constitutive of the Constitution itself. We can trace this idea to the German Constitutional Court. In an early judgment in 1951, in its early years, the court explained that, quote, some constitutional principles are so fundamental and so much an expression of a law that has precedence even over the Constitution that they also bind the framers of the Constitution and those who would change it. Fifth, a court could interpret a constitution as being anchored in an evolved, non-negotiable norm that may not have been evident at the founding, but that the judiciary has, over the course of developing its jurisprudence, identified as a special norm that sits at the apex of the constitutional order. For example, in the United States, an amendment to ban flag burning could be held unconstitutional for violating the norm of wide latitude for political speech, which is currently the most strongly protected form of speech under the Supreme Court's First Amendment case law. Sixth, the court could strike down an amendment because it is a new constitution in disguise. Imagine an amendment that sought to transform the system of government from a presidential system to a parliamentary system, and all of the collateral changes that would entail. Such a change would amount to much more than we expect of an amendment that must be corrective or elaborative. And so a court might therefore conclude that this amendment was really a new constitution masquerading as an amendment, and therefore strike it down and require that its passing be done by the creation of a new constitution. Seventh, a court could find that an amendment is unconstitutional when measured against an unwritten constitutional norm, neither codified in the constitutional text nor the result of the court's jurisprudence. An unwritten constitutional norm underpins the constitutional order insofar as it allows it to operate well. And an example of an unwritten constitutional norm in the United States, one that could compel a court to invalidate an amendment to it, is the norm, the unwritten rule against court packing. I'm also happy to say, incidentally, in our Q&A, why I don't think in the United States a federal court would ever overrule an amendment. Finally, eighth, before I close, a court could invalidate a constitutional amendment if it violates supra-constitutional law. Supra-constitutional law. So for example, constitutional amendments in Nicaragua in 2004 and in Togo in 2005 were held to violate the rules of regional multinational organizations. And so, the domestic court invalidated them as well. So what you could have here is a domestic constitutional court enforcing these supra-constitutional rules. These 8 strategies, or justifications, can help courts guard the Constitution from changes that the court believes would destroy the Constitution's original framework. When courts in Belize and the Czech Republic, in India, and here in Taiwan have imposed or enforced limits on the power to amend the Constitution, they've understood themselves to be protecting the Constitution. For these courts and others, a constitutional change that amounts to what I've described to you as a dismemberment, as a destruction of the Constitution, cannot be authorized by the ordinary rules of constitutional amendment. The lessons from the case law that I've discussed in the time that I've had so far, and the lessons also from the theory of constitutional amendment, which I'm happy to discuss in our time for question and answer, they can be summed up in one phrase, and that's where I will close my remarks for now. The distinction between amendment and dismemberment is central to the self-understanding of courts when they seek to protect the Constitution from its unmaking by ordinary amendment procedures. And on the question whether an amendment can be unconstitutional, I think it is important to say that the Constitutional Court of Taiwan has been a leader, a world leader in showing how it is done and why it is important. And although it's true that there's a very strong line of jurisprudence, a very strong line of scholarship that an amendment should never be invalidated, I think the justification that this court has offered is an interesting one, a powerful one, and one worth thinking about more deeply. Thank you so very much for having me here. It's been a pleasure and an honor.
Thank you, Professor Albert, for your wonderful speech. Now it's time for Professor Su to comment.
Thank you, Justice Tang, Justices of the Taiwan Constitutional Court, distinguished guests, ladies and gentlemen, good morning. It is my great honor to be here, and I would like to share with you a few thoughts I have in response to Professor Albert's excellent paper. Professor Albert is a leading expert in comparative constitutional law and a prominent investigator of the unconstitutional constitutional amendment, which can be abbreviated as UCA. I think Professor Albert's presentation today provides us with a very useful roadmap for understanding what may be considered a renaissance of the UCA doctrine in contemporary constitutional theory and practices. In addition to sharpening the conceptual tools for addressing the persistent puzzle of whether and how the UCA doctrine can ever be justified, Professor Albert also leads us to assess the different uses or applications of the UCA doctrine in numerous real or hypothetical cases. I still have some questions and comments for Professor Albert, though, and my first question has to do with the 8 strategies or justifications for the judicial implementation of the UCA doctrine Professor Albert clearly identifies in his presentation. These strategies differ mainly along 2 axes, whereas some of them focus on the process of constitutional change, others look into the substantive content of the constitutional amendment under review. Some of them seek to enforce norms that are explicitly or deeply entrenched in the large C Constitution, whereas others invoke unwritten or supranational constitutional norms. I think this comparative study is a significant contribution Professor Albert makes to the literature. With this roadmap in hand, we can actually identify and analyze the jurisprudential moves a constitutional court like our TCC made in a given UCA case, like the Judicial Yuan Interpretation number 499. But rather than thinking of these approaches or justifications as different strategies that pursue the same goal, say defending constitutional democracy, I wonder whether at a certain point it makes more sense to speak of them as entailing different possibilities or different conceptions of the UCA doctrine, which may be used to serve different purposes in different contexts. My suspicion comes from Professor Albert's suggestion that the UCA doctrine may be deployed to prevent a presidential system from being transformed into a parliamentary one through the amendment process, as I'm not so sure that in the event that such a structural change happens in Taiwan, the TCC would choose to do so and invalidate the amendment as unconstitutional. So I wonder if we can recategorize these different approaches, strategies, into 2 camps, with the first camp aiming at protecting the existing constitutional order, or to be more specific, protecting part of its identity that has less to do with the commitment to democracy, such as federalism, secularism, or presidentialism, etc. And the second camp seeking to prevent liberal democracy from backsliding. I suspect that the difference between these 2 camps is often a matter of emphasis, but it makes sense to make distinctions like this one on account of what the UCA doctrine is for, because different orientations of this doctrine may confront different challenges in terms of its justification. On the one hand, we may have reasons to worry that the UCA doctrine aggravates the dead hand problem if it is geared to protect or entrench what the constituent power had decided at time one. On the other hand, we may worry less about the rule of the dead, but more about the rule of the judges, the so-called juristocracy, if the UCA doctrine is used to safeguard liberal democracy as an ongoing political project. So I think some commentators, contemporary commentators, advocate for the second vision of the UCA doctrine, but they also have some doubts about its efficacy as a means for what is known as militant democracy. And I would like to know what Professor Albert thinks about this distinction and whether we can observe or trace this kind of philosophical or ideological differences in comparative constitutional law. To put it differently, I think maybe I wonder if it's the case that in applying the UCA doctrine, some constitutional courts are more willing to choose democracy over constitutionalism or vice versa, when these 2 normative commitments are separable or even diverge from one another. My second question is a question of clarification, as I don't know for sure how Professor Albert conceives of the relationship between the amendment-dismemberment distinction on the one hand and the use of the UCA doctrine on the other. Specifically, I would like to know, under Professor Albert's theory, is it still possible for a constitutional dismemberment that was made through the amendment process be held as constitutional under the UCA review? In a short article published at the ICON in 2015, my professor, Mark Toshnod of Harvard Law School, suggests that, quote, sometimes ordinary constitutional processes can be used in the service of a revolutionary transformation. The reason is that, in retrospect, those processes should be understood as exercises of the constituent power itself, not an exercise of a delegate constituent power, unquote. I'm not sure if Professor Albert would agree with Professor Toshnod on this point. Some arguments in Professor Albert's paper seem to suggest a yes, of course answer. Constitutional dismemberment, after all, is first and foremost characterized as a descriptive concept. And Professor Albert uses the Civil War amendments to the US Constitution as examples of dismemberments. But Professor Albert also suggests that the task of the Constitutional Court under the UCA doctrine is to police the boundary separating amendment from dismemberment. Courts in their roles as guardians of the Constitution, according to Professor Albert, must protect the Constitution from unconstitutional change by amendment. This rather sweeping mission statement appears to run counter to the idea that some constitutional dismemberment made through the amendment process could still survive the UCA inquiry. And it seems to me that Professor Albert has sought to dissolve this potential contradiction by trying to further qualify what counts as an unconstitutional or illegitimate constitutional dismemberment. To the extent that we need to resort to something other than the distinction between amendment and dismemberment, or the distinction between the constituent power and the constituted power, to determine whether a formal constitutional change is legitimate or not, I suspect that the conventional wisdom Professor Albert eloquently summarizes in his presentation may have overstated the centrality of the conceptual distinction between amendment and dismemberment in the UCA jurisprudence. By the way, I think the profound identity change of the ROC constitution from a constitution imposed from China to a constitution based on Taiwan is a peaceful yet revolutionary transformation that has resulted in significant part from the constitutional amendments Taiwan had undergone in the 1990s and 2000s, will serve as a contemporary example of how constitutional dismemberment can be legitimately accomplished through the amendment process. So in the remaining of my time here, I would like to recount the development of the UCA doctrine in Taiwan with the hope to solicit more comments and suggestions on the TCC's UCA jurisprudence from Professor Albert and from all of you. And since Professor Albert has addressed in detail the story about the Judicial Reinterpretation number 499, I will limit my historical and jurisprudential account to what happened in Taiwan after this landmark decision the TCC made in 2000. So regardless of how controversial the UCA doctrine is in the constitutional theory, I think it is fair to say that the JY Interpretation 499 enjoyed quite strong popular support at that time. And under the mounting pressure of the public opinion, the National Assembly soon caved in by amending the Constitution again in 2000 to the effect of turning itself into an ad hoc constitutional assembly, the member of which would be elected under a list PR system and could only vote as delegates of the political parties on whether to ratify the constitutional revisions or amendments proposed by the Legislative Yuan, Taiwan's parliament. So under this revised constitutional amendment rule, the Constitution was amended again in 2005, and it remains the last time the Constitution was formally changed in Taiwan. The 2005 constitutional amendments essentially did two things. The first was electoral reform. The amendment halved the size of the Legislative Yuan from 225 seats to 113 seats, extend the legislative term from 3 to 4 years and transform the legislative electoral system into a mixed-member majoritarian system, as Professor Lin Caojun mentioned yesterday. And the second thing was the reform of the constitutional amendment process. The amendment abolished the National Assembly permanently, requiring instead that constitutional amendment be proposed by a 3/4 vote of the Legislative Yuan and be ratified by an absolute majority of the electorate in the constitutional referendum. And the 2005 constitutional amendment was propelled by a bipartisan agreement reached between the DPP and the KMT, the two major political parties in Taiwan. Less than 23% of the voters, however, turned out and voted in the special elections held for the dying National Assembly. Some people in Taiwan strongly opposed the new legislative electoral system, so they challenged the constitutionality of the amendment to the court, and that led to the judicial interpretation 721 the court issued in June 2014. In this interpretation, the TCC, the court, reaffirmed the central holding of the interpretation 499 and reiterate that no constitutional amendments could legitimately alter the fundamental order of liberal democracy. That being said, the TCC upheld the constitutionality of the MMM system, electoral system, along with the 5% electoral threshold, while dismissing the other parts of the petition as inadmissible. One issue present in this case was whether the court's prior jurisprudence on the UCA doctrine should be affected by the fact that the process of constitutional amendment had been changed in 2000, so that the National Assembly, as a representative body, no longer had the power to amend the Constitution on its own volition. And both Justice Tang Dezong and Justice Su Yongqin thought it should be, and they wrote separately to argue that the court's UCA inquiry should henceforth be limited to examining only the procedural constitutionality of the constitutional amendment at issue. But that was not the approach adopted by the majority of the court. The opinion of the court in that case reiterate a list of substantive limitations on constitutional amendments as derived from the fundamental order of liberal democracy, and the TCC upheld the disputed amendments on substantive grounds. While the court granted much leeway to the democratic electoral engineers in that case, its reasoning indicates that the TCC considers itself as having the ultimate and irreplaceable duty to protect the fundamental order of liberal democracy against any unconstitutional amendments, however hard one they may be. So has the substantive prong of the UCA doctrine become obsolete in Taiwan? Since the constitutional amendment rules in Taiwan were changed again in 2005, I suspect that Taiwan might revisit, the court might revisit this issue someday in the future. I think I want to make the last point. There's a question whether we should rely on judicial self-restraint or simply relinquish entirely the substantive prong of the UCA doctrine. And I think while our choice may depend in part on the extent to which we trust or believe that the procedural safeguards built in the amendment process are sufficient enough to defend a constitutional democracy from destroying itself, my hunch is that this doctrinal choice also has to do with constitutional persona or differences in judicial philosophy. So what should I do if my fellow citizens want to go to hell? Perhaps this is the existential question that UCA doctrine poses to every constitutional judge before it. And his or her answer to this question would determine not only what doctrinal choice he or she would make, but also what kind of justice he or she would be. Thank you. I'll just stop here.
Thank you, Professor Su, for your very well-organized and creative commentary. Now the floor is open. Each audience who want to raise questions will have 2 minutes. And before raising your questions, would you please declare your name, title, or position and affiliation? in order to facilitate the proceedings recording. Okay, and if you want to raise question by Mandarin, it's okay. We have an excellent and very capable interpreter to help you. Okay, so you raise the hand.
Thank you. My name's Andrew Jemczewski. I'm from Strasbourg, France. Professor Richard Albert mentioned supraconstitutional standards which can block illegitimate work, if you like, in terms of anti-constitutional. You mentioned the Nicaragua, and if I'm not mistaken, this was a decision taken by the Constitutional Court of Nicaragua, I assume. My real question is, how do you deal with liberal democracy backsliding, for example, in terms of, in Europe, Hungary and Poland? I give you the example of Hungary. You have a majority, fixed majority, which allowed for a 2/3 change of the constitution. Consequently, the Constitutional Court's composition was pushed up artificially from 11 to 15, in effect, putting the Constitutional Court in the hands of the authorities. Similarly, more recently, since 2015, in Poland, you have a situation where the Constitutional Court Tribunal, as it's called in Poland, has been nobbled, whereby it's become ineffective. Tied in with this, I'll try and be crisp and to the point, there is now the European Union rule of law framework mechanism where Poland is deemed to have violated basic democratic human rights rule of law principles within the context of the 28 member states of the European Union. Likewise, one can say, breach of the Convention of Human Rights, akin. In that context, my real question is, and they've taken the case to the Court of Justice in Luxembourg, my question really is there a specific, clear, supra-constitutional international law framework which would allow for the superimposition of certain basic Grundnorm of rule of law, constitutional principles from which countries cannot derogate? I ask this in the context of the Polish President Duda is now coming up with an idea of a referendum in Poland in November. Then he'll change the constitution perhaps, mutatis mutandis, the situation in Hungary. Therefore, by political maneuvers, constitutional rule of law criteria as understood in the European common law of human rights, rule of law standards, will have been definitely changed radically on the basis of appropriate constitutional changes. A bit long, I apologize.
Thank you, Andrew, for the question. Let me also thank Professor Su for his comments and questions, and I will return to those if the chair will give me a moment to do that. Andrew, you put your finger on the critical question in relation to the unconstitutional constitutional amendment doctrine. Is it effective when it's needed most? And there are many examples around the world of the misuse of the doctrine of unconstitutional constitutional amendment. You've asked about the Nicaraguan case, and here you have the domestic court enforcing a supranational norm or a law. What happens when the domestic court refuses to enforce a supranational or supraconstitutional law or norm? And that's what we have happening in the cases that you've mentioned. It's one of a number of cases that we can put together, string together. Turkey, for example, has misused the UCA doctrine. Honduras has misused the UCA doctrine. So I don't mean to suggest that the UCA doctrine is the answer to what ails Hungary, Poland, any number of countries, Venezuela, around the world. But it has been raised as one tool in the entire toolkit if the interest is to protect constitutional democracy from backsliding. Whether it's effective on its own, I think the answer is no. I think the answer is quite clearly no. Tom Ginsburg, seated to your right, has done a lot of important work about constitutional culture. And I think that is where the seeds must be sown to address the concerns that you've quite rightly raised. It is not in an institution like a court that could be staffed by different kinds of women and men who hold different values. It has to be something that comes from within that particular jurisdiction. may I say a couple of comments in response to Professor Su, if I may? So Professor Su, you raised 3 or 4 very important questions that I consider to be friendly challenges to the questions that I've raised, and I want to thank you for those. The first that I want to address in a very short amount of time is your point about the different purposes of the doctrine of unconstitutional constitutional amendment. You suggested that we might think about dividing them into 2 purposes. First, protecting the existing constitutional order, and then 2, preventing liberal democracy from backsliding. I think that's absolutely right. But there's a third. There's a third purpose for which we might think that the doctrine of unconstitutional constitutional amendment is useful. And that is that it could serve a catalytic function for democracy. It could be that where a court invalidates a constitutional change that is a new constitution masquerading as an amendment, that what the court is saying and what it seeks to say is not that this change is impossible, is impermissible in all circumstances, but rather that if you want to infuse this change with democratic legitimacy, you need a greater amount of popular participation to legitimate the change. So you cannot make a big change, whatever change you want to suggest, let's say the move from parliamentarism to presidentialism. That cannot be done by simple parliamentary majority vote. I want to suggest it should not be done by a simple parliamentary vote. And so a court could say that this change is unconstitutional under the current constitution, but that it may be done with more participation, perhaps a referendum, for example, perhaps something else, something more that catalyzes the democratic process so that we can legitimate the change, that it is not just the change in the minds of the legislators, a simple majority of them. Second question that I think was quite important, Professor Su, was whether a dismemberment can ever be held unconstitutional, can ever be held constitutional when made using the amendment procedure. And here I think the way to answer your question is to think about 2 kinds of constitutions. And let's talk only about codified constitutions for now. There are 2 models around the world of codified constitutions that codify amendment procedures. The first model is the standard model, which codifies rules for amendment and amendment alone. The Constitution is silent, in other words, about how we can dismember the Constitution. That's one set of constitutions. The overwhelming majority of constitutions do that. This Constitution does that. It gives you procedures only for amendment. More modern constitutions, although not all of them are recent, but many of them are, they will codify procedures for both amendment and dismemberment. They will lay out a roadmap for how to make changes and legitimate changes that amount to a transformation of the constitutional order. How? They will give you different thresholds for amending different parts of the Constitution, for dismembering different parts of the constitutional order. Austria's Constitution, which is old, 1920. The Spanish Constitution, 1978. The Costa Rican Constitution. The Canadian Constitution does this as well. All changes, from the mundane and technical to the transformative and revolutionary, are given procedures for how to be made in these second category of constitutions. And so in that case, Professor Su, that's an example where a dismemberment can be held constitutional because it is made in conformity with the codified rules of change. The problem of classification that I suggested at the beginning of my remarks, that problem arises principally where the Constitution is silent about the 2 paths of change, where the Constitution says only how to amend it, but not how to dismember. One last word. The constitutions that codify rules for both amendment and dismemberment don't use the term dismemberment. They will use different terms. They will say, for example, here's one procedure for partial amendment, and here's one procedure for total amendment. Here's one procedure for partial revision. Here's one procedure for total revision. So this is a language that constitutions use. And I think this is the better way of designing a constitution. Why? Because it serves the purpose and the interest of legal continuity. Rather than breaking legal continuity in the face of a constitution that doesn't codify rules for dismemberment, for transformative change, these constitutions, Canadian, Austrian, Spanish, Costa Rican, and a few others, give you the full scope of procedures for the full scope of changes that can be made. In Canada, we can formalize a secession through amendment of the Constitution. A transformative, revolutionary, radical change that can be made through a procedure in the Constitution. Now, we don't know which procedure because the court didn't tell us which procedure. And I think as a political matter it didn't. But this is, I think, an answer to your question that it is possible. And I think I will hold there.
So from the floor.
Thank you, Chairman. Chang-Fa Lo from the Taiwan Constitutional Court. I have two brief questions for Richard. The first one is about the idea of having some kind of supranational constitution or constitutional norm. I'm wondering whether this idea can be linked to some more solid textual norms that we can identify so as to make it work. For instance, could we, is it possible or operable to say, for instance, certain human rights treaties or certain principles in the existing human rights treaties should have such status of being followed by countries, and therefore countries, including the constitutional norms in those countries, so that it becomes, or the group of human rights treaties of that kind become the of the nature of supranational constitution. This is just an idea to further elaborate your thought so as to make it probably more workable. Another point is about the relations between the strategies or the justifications in different categories. I think in many countries, there are some rules provided in the Constitution about how to amend the Constitution itself. But the rules tend to be not so specific, not so detailed, so as to tell the Congress about how to vote, how to discuss how to vote. Let's suppose that certain procedural aspect is not that clear in the Constitution or in the constitutional practice. But they involve some substantive problems constitutionally. So is there a possible understanding of your principle to say this is about the relations between different categories of the principles or the justification? Is it more possible for a constitutional court to challenge the procedure plus the justification, so as to say, well, this is non-justifiable, then merely challenging the procedure? In other words, if procedure plus substantive constitutional problem can be identified, are we in a better position to challenge the procedure? This is the relations between or among different justifications. Thank you so much.
Thank you, Justice. So two questions. The first question is whether the justification for invalidating an amendment on supranational, supraconstitutional norms. Whether there can be or whether there are examples of that around the world, where there's a textual referent that gives the court the power to invalidate the amendment for violating some kind of human rights treaty, for example. I think I've captured your question correctly. And I can give you two examples. The first is the Constitution of Switzerland. The Swiss Constitution says, makes a number of things unamendable. And one is that the rules of international law are unamendable, inviolable. It doesn't use the language unamendable. They're inviolable. And every action taken by political organs must be consistent with international law, or that risks invalidation. And so that is one example where we have the rules of international law codified in the Constitution itself, the domestic national Constitution itself, which can lead a court to then exercise the power to invalidate an amendment that is inconsistent with a human rights treaty, for example, which was what you asked. The Constitution of Bosnia-Herzegovina is similar as well, because it commits the state and all of its organs to respecting all of the human rights treaties that it's party to. That is another hook, textual referent for the court to be able to invalidate any action, including an amendment that is inconsistent with a human rights treaty. So those are two examples. Your second question is I think, a difficult question, because it asks about the distinction between procedure and substance. And of course, sometimes there's a blurry distinction between procedure and substance. Let me give you an example. It's an example that I was discussing just a couple of days ago, in fact, with some members here. The Constitution of Mexico has a very interesting provision in Article 136. And it says that in the event of a rebellion that leads to the creation of a new constitution, that new constitution shall be null and void until and unless rightful order is restored to the state, at which point the people who mounted the rebellion will be prosecuted and order will be returned. Another example, and I'll connect them, is from the United States Constitution. Article 5 codifies a rule called the Equal Suffrage Rule. The Equal Suffrage Rule guarantees, by its text, that every state, 50 now in the US, will have 2 senators in the Senate. You can diminish a state's representation in the Senate, but you need that state to consent. And I gave the example in my remarks of Rhode Island. You can take away a senator from Rhode Island so that all 49 others will have 2 and Rhode Island will have 1. You can do it, but Rhode Island must consent. Now, these are 2 examples of constitutional provisions in Mexico and in the United States that seem to be saying that we want to protect a procedure. In Article 5, the procedure is that Rhode Island must consent. In Mexico, the procedure seems to be, a prohibition on the writing of a new constitution. You cannot write a new constitution as a result of a rebellion. There are a number of problems that that raises. What is a rebellion? What's the difference between rebellion and revolution, right? So by the language of these 2 constitutional rules, they seem to be protecting procedure. But on the other hand, you could understand them as protecting substance. So what Article 5's Equal Suffrage Rule really protects is federalism. It's not the process by which Rhode Island would give its consent to losing a senator. It's really the idea of equality, connected very closely with the idea of dual sovereignty at the founding. Similarly, in the Mexican Constitution, what's being protected is not the process by which we write a constitution. It's the principles in this constitution. And it's a very strong declarative statement about how important the principles of the 1917 Revolutionary Constitution are. So it seems to me that the distinction between process and substance is very, very difficult to parse out. But your question was, can a constitutional court be said to be standing on firmer ground where it is invalidating an amendment on procedural and substantive grounds than on simply procedural grounds? And there I think the answer is yes. There I think the answer is yes. Now Turkey has run into some difficulties with how it administers, the Constitutional Court administers its own power to review constitutional amendments. In Turkey, the court has the power to review amendments, but the Constitution circumscribes that power only to reviewing amendments for their procedural correctness. Procedure alone. What's happened is that until the year 2016, the Constitutional Court of Turkey ventured beyond procedure into substance, saying that it cannot determine whether an amendment is procedurally correct without investigating the substance of the amendment. And that was how the Constitutional Court of Turkey was able to get in through what some call the back door, substantive review of amendments, while latching onto its power of procedural review in the Constitution. Since 2016, however, the Turkish Constitutional Court has returned to looking at amendments only according to their procedural correctness. But it's a very fuzzy line. But your question, I think, my answer is yes. A court is on much stronger ground when it can marry both procedure and substance.
You can speak in Chinese, Mandarin. We have an excellent translator. Okay.
I understand a bit of Mandarin.
Yeah, wonderful. Okay, Justice Zhang.
Yeah, my name is Zhang. I'm also a Justice of the Constitutional Court of Taiwan. I have two questions which are related to each other. The first one is quite simple. Is referendum a legitimate procedure to amend the Constitution? And the second one is just suppose that one day in Taiwan, a referendum has been passed, and according to which the protection of life contained in the Constitution does not preclude that death penalty should be allowed in the Constitution. And accordingly, our legislation passed an amendment or additional provision to the Constitution. Is the code, our code, Constitutional Code, still entitled to declare that such amendment is against the fundamental principles of Constitution? Therefore, such amendment is unconstitutional. Thank you.
Thank you, Justice, for the questions. On the question of referendum, the question is a referendum a legitimate way to change a constitution? And I think the answer depends. The answer depends on the country and the constitutional tradition in that country. I think it's possible that a referendum is not only a legitimate way of amending the Constitution for a given country, but it's also a legitimate way of dismembering the Constitution in a given country. So for example, in France, a jurisdiction that does not recognize the existence of an unconstitutional constitutional amendment, courts have said on more than one occasion that there is no such thing, there can be no such thing as an unconstitutional constitutional amendment when the people have spoken by referendum. There, the referendum is the equivalent of an exercise of constituent power. That is the French tradition of constitutional change. When we mount the necessary energies to make a change to the Constitution by referendum, we can rewrite the Constitution, we can amend the Constitution, we can dismember the Constitution, and the court has no power to review that. But I don't think that's the case for all countries. There is no tradition of referendal change in the United States, for example, at the national level. At the state level, yes. But at the national level, there isn't. And so, just because in France, one can rewrite the Constitution exclusively and only with a referendum, in the United States, that would be inappropriate. Not because I say so. Doesn't matter what I say. It would be inappropriate because the rule of recognition would foreclose it. A referendum would not be recognized as a valid exercise of constituent authority in the United States. Why? Because it's a federalist country, and we recognize proper changes only when there is validation by national actors and validation by state actors. Now, there are other theories that I think go the other way. There are other theories that would have a different view, but I think those theories are incorrect because it matters what the political actors recognize as being valid. So I don't yet know enough, but I'm learning more by the day about Taiwan's constitutional history. And so I'm not yet ready to be able to answer the question whether a referendum here would be sufficient either for an amendment or for a dismemberment. But that's where we would look for the answer. And it's also not to say, Justice, that because a referendum today is or is not considered a legitimate way, a legitimate modality of change, that it will tomorrow not be a legitimate modality of change. Because times change, social conditions change, political conditions change, the rule of recognition changes. The second question was about the potential for life and its interpretation, and whether that might not preclude the death penalty. And you asked me to imagine an amendment here to the Constitution. And again, I would have to know much more about the Constitution, because what amounts to a dismemberment is not it's not a universal answer. It's an answer that applies to a particular jurisdiction at a particular time. It's a particular equation. And so when I suggested a moment ago that it would amount to a dismemberment to move from a parliamentary system to a presidential system, that's not for all jurisdictions. Just as it would be the case that what amounts to dismemberment in the United States, flag burning amendment, for example, it might not be the same in another country. So we do need to know a lot about the local norms to be able to identify what a dismemberment is, because it really is deeply, deeply connected to the people and their histories. And I think that's the way it should be. I think that's the way it should be. I think it's important to have universal values and universal norms, but a constitution is a national product of a national identity. And I think it would be a difficulty, I think, to say, I would have difficulty saying that there is a one-size-fits-all rule for all constitutions of the world, that all should follow a particular understanding of rights or liberties.
Okay, due to the time limits, I think this will be the last question from the floor. You want to raise again, or somebody else? Tom? Okay. And
no objections. It's a second point of information to tie in with your issue of whether or not constitutional courts feel bound by certain human rights treaties. When joining the Council of Europe, the 47 member state organization in Europe, the countries of Central and Eastern Europe had to accommodate to certain human rights standards to ratify the Convention of Human Rights within a certain time period, and tied in with death penalty, they had to ratify the 6th protocol to the European Convention of Human Rights, which abolishes the death penalty. There were examples of, I'll say it very quickly, 3 constitutional courts of Hungary, Albania, and Ukraine, which interpreted their criminal codes, which allowed for the death penalty, had to be interpreted in the light of European human rights standards, Protocol 6 of the Convention, and thereby the judicial legislation by means of complying with European human rights standards.
You still want to raise a question? Keep it short, please.
Very short. This relates to the question just raised by my colleague, Justice Zhang about the procedure. Let's suppose, well, this is hypothetical. Let's suppose there are two procedures to amend the Constitution. One is merely by the Congress itself. So this is a separate procedure. Another procedure is, in addition to that, prior to that, or before that, or after that, I'm sorry, there has been an approval by certain high percentage of the whole population. So when a constitutional court faces an interpretation of an amendment passed or having gone through different process, do you think the Constitutional Court would have to be more careful, would have to pay more deference to those amendments which have been very vastly approved by the whole population?
Thank you for the question, and I think the short answer is yes, but. Yes, but. So, in this Constitution, are there unamendable rules? In Taiwan, there are none. But in this hypothetical Constitution, are there unamendable rules? Second question that I would need to know, does the Constitution's amendment rules tell you which of these two procedures must be used to amend which particular parts or provisions of the Constitution? That is from where the court should take its cue. But if we don't know either of those things, if there aren't any unamendable rules, if the Constitution does not lay out expressly what is subject to amendment by congressional vote alone and what is subject to amendment by congressional vote and referendum vote, and the court is faced with this silence in the Constitution, what must the court do? What can the court do? How should the court regard amendments made using the second procedure of congressional approval and referendal approval? I think my answer is that the court should be more deferential to those amendments if there is a tradition, a recognized tradition of seeking the views of the people. Now, this of course assumes that the vote is done in a procedurally regular way, that it's done with informed voting. But if those two things are satisfied, then I do think that the court owes more deference to those kinds of changes, because this goes to the very nature of what a constitution is. A constitution is a document, a set of rules that binds people together, that binds the state to the people, that gives duties, that gives rights. And I don't think it's appropriate for this kind of a document, a thing, it's not always a document, to be unchangeable. So these things must be able to change. And the closer we get to a configuration of approval that matches the constituent power, whatever is recognized as a valid exercise of constituent power, the closer we get to that, the more deferential the court should be. Related point, the easier to amend a constitution, the more assertive the court should be to reviewing the constitutionality of amendments. In the United States and in Canada, it's very difficult to amend the Constitution. In the United States, I was going to say it's impossible. That's not true, but it's close to impossible. There hasn't been an amendment since 1992, but that amendment was under debate for 200 years. It was proposed by Madison, in fact. It's very difficult to get the right agreement in the United States to amend the Constitution. In Canada, it's not impossible. We've amended our Constitution many times, about 11 or 12 times since 1982, and only once using one of the two most difficult procedures. There's a unanimity procedure, there's a multilateral default procedure. Both are very, very difficult. But where the Constitution is difficult to amend, I think the court should be more deferential to the actual process, the product of the amendment. Where it's easy to amend the Constitution, as in India, I don't think it's a surprise that the Indian Supreme Court created the basic structure doctrine in a context where all you need is a simple majority to amend the Constitution with a 2/3 quorum. It's not a surprise that that is where the basic structure doctrine comes from, because it's very easy. You treat the Constitution just like a statute. No, there should be more assertions of judicial authority when it comes to a Constitution that is basically like a statute. Thank you very much for your question.
By the robust discussion, I still have to abide by the rule set up by the conference, and it's time for lunch. So thank you very much for your participation, and see you around. This is the end of the session. Thank you.